Good. So, morning, Albert. So, today we'll be doing conveyancing, past paper 2024. And we'll start with the first question that reads as follows. Charity is planning to set up a mixed-use development on a parcel of land reference number 209, measuring 100 by 100 meters. She bought this land in 2007 at 8 million Kenyan shillings after securing a financial accommodation from ABC Bank. She has repaid the loan and now has a balance of 4 million Kenyan shillings. The parcel of land is now valued at 24 million Kenyan shillings. Charity is now desirous of applying for a loan of 20 million Kenyan shillings from Atlas Bank to actualize her dream of putting up the mixed-use development. 1. Charity has approached you for legal advice on the steps to be followed in the disclosed circumstances to secure funding of 20 million Kenyan shillings from Atlas Bank. With reference to statutory law, proceed to advise 5 marks. B. RML Advocates LLP have been appointed to represent Atlas Bank in the transaction. State the due diligence they will undertake to protect their client's interest, 5 marks. Then you're supposed to compute the stamp duty payable with respect to the transaction between Atlas Bank and Charity. Then D. Charity has experienced tumultuous financial times after securing the financial accommodation from Atlas Bank. As a result, Charity has defaulted on loan repayments and the bank has already complied with the legal procedure necessary for exercise of the statutory power of sale. The mixed-use development is slated for public sale by auction in 7 days to come. Explain to Atlas the necessary prerequisites that should exist to permit it to sell the property. 5 marks. Explain to Charity on equity of redemption in light of circumstances referred to in D above. So that we understand, there is a person known as Charity who is planning to set up a mixed-use development on a parcel of land. She bought it at 8 million in 2007 after securing a financial accommodation from ABC. She has repaid that loan and now has a balance of 4 million from ABC Bank. But now the parcel is valued at 24 million Kenyan shillings and Charity is desirous of applying for a loan of 20 million Kenyan shillings from Atlas Bank to actualize her dream. Now Charity has approached you for the legal advice on the steps to be followed in the disclosed circumstances. Now the examiner expects to hear from you the statutory law that Charity is to comply with so that she can be given this 20 million from Atlas Bank. So maybe Albert, you can attempt the questions as we put it on scale on the marking scheme. Others will join later. I've already DM'd them.
Yes, good morning, Victor.
Good morning.
My speaker is so low, so I'm trying to read through. Now, what's coming to my mind, I think perhaps is the issue of tacking and consolidation of charges, whereby what's required, in my view, is to use the same property to secure another loan from another bank, yet the same property had already been used to secure the first loan from a completely different bank. Now, I think I would first advise that I would advise Charity to first disclose that before she approaches Atlas. She discloses to Atlas that the property she intends to use as security was already used to secure another loan using ABC, right? Is it ABC Bank? And that the loan obligation has been serviced to a certain extent. Then we shall now need a professional undertaking to be given to here I'm not sure. To be given to here I'm not sure. You'll just get me where I'll be wrong. To be given to ABC to discharge the property with an undertaking that immediately they discharge a property, some of the loan that will be acquired from Atlas will be used to directly finance the debt and service it, to finance or service the debt in ABC to clear it first, such that now Atlas can have the property charged in their name, and then the balance out of that which will have been secured, the balance of the 20 million now, if you deduct the one that will be servicing the debt in ABSA, is what now charity will be given to continue with her personal developments as she wanted.
Thank you so much, Charo. We'll test the response against the marking scheme, but you have already captured the nitty-gritties that the examiner is expecting to hear, save for the statutory law that you are basing your answer on. Now, Mr. Martin, the question before the screen is the full question. It is starting from charity all the way to question E. So in the meantime, you could be reading through so that you understand the questions that we are posing. Then question B, are male advocates, or we can confirm first the first answer to A before we jump to B so that it will be a flowing session. So part A of the same says that the steps that charity should take to secure 20 million from Atlas Bank is that the land is still charged to ABC Bank for an outstanding balance of 4 million. Charity cannot give Atlas Bank an encumbered first ranking charge against ABC's bank security until ABC's bank security is discharged or transferred. So step number 1 is to apply for the facility. Charity should submit to Atlas Bank a formal loan application, identification, KRA PIN and income information, the title to LRA number 209885, the current valuation report, development plans, approvals and cost estimates, evidence of our ability to repay, and details of ABC Bank's existing charge and outstanding balance. If satisfied, Atlas Bank will issue a letter of offer for 20 million Kenyan shilling, setting out the interest rate, repayment period, security, conditions precedent, and even default provisions. Charity should accept the offer and obtain independent legal advice on its terms. Now, the second step is for charity to redeem or transfer ABC's bank charge. So charity should obtain from the ABC Bank a redemption statement showing the precise amount required to settle the debt, an undertaking to release the title upon repayment, and a duly executed discharge of charge or transfer of charge. Because Atlas Bank may now apply part of 20 million, approximately 4 million, to settle ABC Bank directly. So two structures are applicable: discharge and fresh charge. ABC Bank executes a discharge and Atlas Bank registered as a fresh first charge for 20 million. Or option number 2 is where we have transfer and variation. This is where charity requests ABC Bank to transfer its charge to Atlas Bank after settlement. This is provided under Section 86 of the Land Act, followed by a memorandum increasing the secured sum to 24 million under Section 84. Now, a second charge is legally possible under Section 79(2) of the Land Act and Section 57 of the Land Registration Act. but ABC's bank's prior written consent will be required and ABC will retain priority. Atlas Bank is therefore likely to insist on becoming the first chargee. Those are the two possible answers that you can give the examiner there. Don't worry, we'll have to revisit the steps in a brief manner. Now, step number 3 is to execute the security documents. Charity will execute the charge or transfer memorandum of variation, the facility agreement, a statutory declaration concerning marital status, spousal consent if the property is a matrimonial home, insurance documents, direct debit or repayment mandates, and any other collateral documents required by Atlas Bank. Under Section 79(3) of the Land Act, a charge over a matrimonial home is valid only with the spouse's asset. Execution must also be verified in accordance with Section 44 and 45 of the Land Registration Act. Step number 4 is to obtain consents and clearances. If the property is leasehold, charity should obtain 1. The lessor's consent to charge, land rent clearance, land rates clearance, and any other consent required by the title. Under Section 56(4) of the Land Registration Act, the registrar will not register a charge over leasehold land without the prescribed consent to charge and land rent clearance. For the mixed-use development, charity should separately obtain development permission under the Physical and Land Use Planning Act, environmental approval where required under MCA, and construction approvals under applicable county and national construction authority requirements. Then we have the last step known as stamp and register the instruments. The transfer or discharge, variation or fresh charge should be assessed and stamped under the Stamp Duty Act, then lodged for registration at the Lands Registry. A formal charge takes effect only upon registration under Section 79(5) of the Land Act and Section 56(3) of the Land Registration Act. Upon registration and satisfaction of all conditions, Atlas Bank will release the balance of the facility for the development. So this was a technical question where the examiner was expecting to hear a technical approach from a student. We started with the steps to take. So charity should first approach Atlas Bank to secure the 20 million from Atlas Bank, and she should apply for that facility. And now this is where you give the two structures that charity can follow concerning the ABC's bank charge. We have said that a charity can either apply for discharge and fresh charge. So this is where ABC Bank will execute a discharge and Atlas Bank will register a fresh first charge for 20 million Kenyan shillings. Then under Section 86 of the Land Act, we have been told that a charge can be transferred. So ABC Bank can transfer its charge to Atlas Bank and with written consent. Then it is followed by a memorandum increasing the secured sum to 20 million under Section 84. So this is where ABC Bank does not want to register a discharge, but they are willing for the transfer to happen. Now, a second charge is legally possible under Section 79(2) of the Land Act and Section 57 of the Land Registration Act, but it must have ABC's bank prior written consent. So this is the tacking provision that Albert was saying, where we have the first charge, then the second charge, and one of the banks now wants to have a priority against the other when it comes to enforcement. Now, remember, after you have dealt with the issue on the ABC's bank charge, the examiner is expecting now to hear how you have executed the security documents. Are you aware of the Section 79(3) of the Land Act, where a charge over matrimonial home will be valid only with the spouse's consent? That will be important, and it's where the examiner will be interested in under the execution of the security documents. And then, because you have been told this property is a mixed-use development property, do you know that for mixed-use development properties, you must obtain consents from relevant bodies like the Physical and Land Use Planning Act authorities, CCMs, wanaitangwa County Executive Committee members, and then environmental approval under MCA, construction approvals applicable under county and national construction authority requirements. That on its own also carried marks. Then are you aware that you should register the charge? Because it is a formal charge, remember, it must be registered for it to come into effect. So it is only upon registration that it will come into effect under section 79(5) of the Land Act and section 56(3) of the Land Registration Act. So those are the nitty-gritties that the examiner was expecting to hear from your answer. And now I believe Albert the same has guided you accordingly on how to approach question A on charity. Now we can move in swiftly to the second question. Welcome, Abigail, where it says that RML Advocates LLP have been appointed to represent Atlas Bank in the transaction. State the due diligence they will undertake to protect their client's interest. Now you are acting on behalf of the Atlas Bank, the second chargee. Second chargee. Chargee is the one taking the loan facility. The second chargee. Now you are acting for Atlas Bank. What is the due diligence that you will undertake to protect your client's interest? So that is a bit easy. We can have suggestions coming from you. Even the first answer already exposes some of the mandatory due diligence that you must consider in such a transaction. Any member, what are the due diligence that you can undertake as RML advocates? Any attempt? Or briefly, you can check about section 79(3) of the Matrimonial Properties Act on spousal consent. That is a very important one. You can check on LCB consent or obtaining of the same. You can also do a historical search. You can do a registry search. So there is a historical one where you are navigating through the green card, and you can also do the one for only showing the current user. You are also expected to do confirmation of the approval for multi-use mixed-use development from the CECMs. You can also do a due diligence to confirm that a written consent has been obtained from ABC Bank, because you are dealing with a charged bank, and that will help you to see what kind of arrangement will be used when it comes to facilitation of this kind of transaction. Remember, when you'll be doing the real setups like these ones in the ground, you will be expected to submit what you call extended due diligence report. And an extended due diligence report indicates various aspects, like even you Google the land reference number against the Kenya law report to see whether there is a case against that parcel. So if there is also a case law, you indicate in the extended due diligence report. So those are the preliminary due diligence expected in such kind of a situation, but we can also test it against the marking scheme. Due diligence by RML Advocates LLP for Atlas Bank. So RML Advocates should undertake the following due diligence. They should verify charity and her capacity. The advocates should verify charity's national identity card or passport, KRA PIN, address and contact details, marital status and spousal consent where applicable, source and purpose of funds, and capacity to enter into the facility and charge. This also satisfies applicable anti-money laundering and client due diligence requirements. That is very important. 2. Investigate the title. They should conduct an official search and obtain a certified copy of the register to confirm that Charity is the registered proprietor, the land reference number, acreage and tenure, the unexpired list term, restrictions on use or development, caution, restriction, inhibitions and easements, existing charges and other encumbrances, and whether the title is presented is genuine. They should inspect the original title and, where appropriate, investigate its truth and prior dealings. Step number 3 is deal with ABC's bank prior charge. So RML advocates should 1. Confirm the amount secured and outstanding, review the existing charge, obtain ABC's bank redemption statement, procure an undertaking to release the title, arrange direct payment of the redemption sum, and obtain a discharge or transfer of charge. They must ensure that Atlas Bank acquires the intended first ranking security. If Atlas accepts a second charge, ABC's bank written consent is mandatory under Section 57(2) of the Land Registration Act. Now, step number 4, valuation and physical inspection. Atlas should obtain an independent valuation confirming the current market value, forced sale value, location and measurements, developments and occupation, access to the property, and suitability as security. The advocates should also compare the title and survey plan with the property on the ground and confirm there is no boundary dispute, encroachment, or even adverse possession. Since the property is valued at 24 million and the proposed loan is 20 million, the loan to value ratio is approximately 83.3%. So RML should advise Atlas whether that provides a sufficient margin after interest, recovery expenses, and forced sale discount. Okay, so you are also supposed to do an independent valuation to confirm. You don't merely take out the figures laid out by the person taking out the loan. The other due diligence expected from you is the regulatory, financial, and litigation searches. The advocates should verify county land rates and national land rate, permitted use and zoning for mixed-use development, approved architectural and development plans, environmental and construction approvals, pending litigation affecting charity of the land, bankruptcy or insolvency proceedings, compulsory acquisition or road reserve issues, and existing tenancies and occupants. They should also ensure that all buildings are or will be adequately insured in the joint names of Charity and Atlas Bank, consistent with Section 88 1D of the Land Act. So basically, the examiner is just telling you, you have seen that kind of a transaction. Kindly give us the various due diligence that you can conduct and register the same in the extended due diligence report that you must submit to Atlas Bank as a worker in RML Advocates LLP. So we have seen the first due diligence is to verify the person who is applying for this loan, know your client details, also know about the regulations that were enacted when it comes to conveyancing transactions. You should investigate the source and purpose of the funds to avoid anti-money laundering issues. You should investigate the title on its own. This is why you engage now the searches. And then we have seen that another due diligence is to confirm ABC's prior charge condition. And if Atlas Bank, now your client, accepts to a second charge, now ABC's bank written consent will be mandatory under Section 57(2) of the Land Registration Act. So confirm that that written consent has been obtained from ABC's bank before you register Atlas as the second charge when it comes to rank in priorities. Now, we have also seen that because the client has approached you with her own valuation report, you should do a valuation and even physical inspection. This will counter issues to do with adverse possession, confirm boundary disputes, and even get the exact current market value because the client could have exaggerated. Now, and lastly, we have seen regulatory, financial, and litigation searches. So this is where you have encompassed all the consents required when it comes to the project itself, bankruptcy of the individual, and whether there are existing tenancies and occupants, because you must serve them a notice so that if they want to continue until a certain duration of time, they can confirm in writing. And now that is the exact procedure that is required. I was doing one of the transactions where a person had already filled in a a letter of offer from one bank, but now he was expecting that the bank will offer this loan in partial compliance to ABC, to another bank. So he was expecting that he would receive this loan and pay a little bit of it to the other bank, but the other bank to release its title. So remember, for the other bank to release its title, an advocate will issue a PU confirming that the rest of the amount will be remitted to on their behalf if they release this title. So that appeared tricky on our end, because I asked him on how the balance of the discharge amount will be settled, and he appeared to be hesitant. So I had to contact the bank for them to issue out a clear written instruction on what they have agreed with the client. If that is what the bank is intending to engage in, then our PU will be based on the condition by the bank that we have relied on your loan offer in giving out this professional undertaking, but still that will be dangerous until the bank remits that fund to the advocate's account. So some clients will never know their motives, so it is better to spot such kind of risk affairs in the preliminary stages. Now, compute the stamp duty payable with respect to the transaction between Atlas Bank and Charity. There is an individual who told me that you can't miss a calculation of a stamp duty rates in a conveyancing paper that you'll ever see it. If you confirm all the trends in all those years, there is a computation and it carries either 4 marks or even 2 marks where the facts are straightforward. And even capital gains tax we saw in one paper. So compute the stamp duty payable with respect to the transaction between Atlas Bank and Charity. So this one I leave to you members to try out how to compute the stamp duty payable with respect to the transaction between Atlas Bank and Charity. What are the various rates of calculating stamp duty that you can try out as we confirm? Yes, Abigail?
The various rates for calculating stamp duty. Number one is okay. The first one is inakwanga set at 4% for urban properties, especially those known for, including those in inakwanga in major cities such as Mombasa, Nairobi, Kisumu, etc. Then 2% for rural properties. And so in this case, we know that it's a property. Is it indicated somewhere? But I've calculated using 4% because I'm not sure if it has been indicated somewhere, if it's in Nairobi or Mombasa, but I have used 4% of the 20% because we've been told to compute the transaction between Atlas and Charity. So my answer has come to 8,000 Kenya shillings.
Thank you so much, Abigail. Let us confirm the marking scheme to see whether you could have scooped the marks. And stamp duty payable, a charge is generally assessed at 0.1% of the amount secured under the first schedule to the Stamp Duty Act. So if Atlas Bank registers a wholly fresh charge for 20 million, so it will be 20 million times 0.1%. However, Section 5 of the Stamp Duty Act prohibits charging stamp duty twice where a borrower moves a mortgage from one bank to another. If ABC's bank original charge secured cash 8 million and was duly stamped, it is transferred to Atlas and increased to 20 million, then stamp duty should ordinarily be charged only on the additional 12 million Kenyan shillings. So this is where you will minus 20 million minus 8 million, and then you will now subject the additional amount of 12 million against the 0.1% stamp duty. Therefore, the preferable answer on a transfer and variation structure is 12 million. 12 million, subject to confirmation that the original ABC charge was for 8 million and was duly stamped. If those facts cannot be established, the fresh charge duty is 20 million. So now, hii imetuleta to a certain all new aspect of looking at this kind of question. Remember, we had two options before we decided to choose one. But the examiner may be expecting to hear from you that you are aware of a stamp duty rate on a charge, not on a transfer. So that is very important there. So there is 0.1%, maybe for rural, and the other one was, I believe, 0.01, but I'll confirm. I don't know where the property is for rural, but it is a charge. Kuna difference. Maybe somebody can also confirm on our behalf so that we know this 0.1% is to apply for rural, for urban, while the other one is for rural. Another person can confirm that. So the key takeaways that we can borrow from this answer is that if Atlas Bank registers a wholly fresh charge for 20 million Kenyan shillings, then you will subject that amount directly to the percentage of 0.1%. But however, there is a prohibition that you cannot charge stamp duty twice where a borrower moves charge from one bank to another. So if Charity decided to do a variation and transfer his charge from ABC with the ABC's bank consent to the new bank Atlas. So if ABC's bank original charge secured 8 million and was duly stamped, and it is transferred to Atlas and increased to 20 million, so duty should ordinarily be charged only on the additional shillings 12 million, because already the first ABC's bank original charge was also stamped. So to avoid any double taxation situations, you will now charge the additional 12 million Kenyan shillings that the new bank is willing to offer. So that is the key takeaway that I wanted it to come out clearly, to avoid a situation where imekuja ukaambiwa a client has decided to transfer, to do a variation of the charge instrument to another bank. So don't do a double taxation in such situations. You only stamp the additional amount offered by the second bank. So I believe somebody was confirming the percentages when it comes to 0.1% versus another rate, for us to be on the safer side, and bearing in mind this is a charge instrument. Stamp duty rates for charge properties in Kenya. So my quick answer is saying that you charge for stamp duty rates for a charge. This is where we have a security or mortgage taken over a property in Kenya is 0.1% of the total principal loan amount secured. But if you are dealing with a discharge of charge, this is where you want to release that security, the rate is 0.05% of the originally secured amount. So be keen on that. Now, if you're dealing with transfer, like Madam Abigail has tried to answer, for transfers, it is 4% for urban properties, for municipal properties, but for rural properties outside the municipalities, you will charge at 2% of the market value. So let us be keen on that. When it comes to charge of all properties, whether urban or wapi, that's why they never indicated, it is 0.1%. But if there is a discharge that is required, then you take 0.05% of the original loan amount. Okay, so that is what will go there under, and you have seen a certain exception under Section 5 of the Stamp Duty Act. Yes, Mr. Martin.
Hello, good morning.
Good morning.
Now, a quick one. I'm just, can you repeat again on how you're going to apply the 0.05%? Now, here we are talking a situation where there is a possible discharge. So, in that case, then it means that the 8 million, if there's going to be a discharge, because it seems like you just applied the 0.01 without showing the discharge. So if you're to consider discharge, are we not going then to be able to say the 8 million has been discharged? So in that case, you do a 0.05% on the 8 million and then 0.01 on now the 12 million. Will that be the mathematics that you have?
Good. That will be the mathematics, because 0.05 is tied on the original loan amount. Yeah, so I'll have considered that. If there is a discharge, I do 0.05% of the original loan amount being 8 million. Then I also subject now the new terms that is to be offered by the new bank under now the charge. The law prohibits double taxation of the charge, but not about the discharge, because you should discharge the original loan amount first. Yeah. I agree with you on that aspect.
So in this case, how would the examiner have probably, so they wanted to have probably looked at the discharge and where you have the other scenario that you have the two banks having the two charges.
Good. Remember, the question carries 2 marks. So there are other situations where the question carries 4 marks. So to be on the safer side, if it's a 2-mark question, the examiner is expecting to see the applicable rate of 0.1%, and now assuming that Atlas Bank will register a wholly fresh charge for 20 million, you expect to see a direct translation of that. But because you want to show the examiner that there is an exception if the client decided to choose the variation angle, this is where now you invoke Section 5 of the Stamp Duty Act, and in doing so, the examiner will see that you are well read, and automatically the 2 marks will be secured easily up to that front. Because there is also another element that you have also brought on board about discharge. So you can also tell the examiner, if the client decided to engage ABC in first agreeing for a discharge of their own charge, so that these funds can now be used to settle that discharge amount. That is also another aspect of showing the examiner, hey, look, apart from 0.1%, I also know that stamp duty attracts 0.05% for discharge. And now you also expect to see the original amount being subjected to the discharge percentage. So this is merely a discretionary point of view, but in my view, nothing will harm you in showing the various dimensions, because at the end of the day, you are only told to advise the client on possible ways of dealing with such situations, and we don't know CLE can decide to take one of the situations and run away with it. So at least now we have mastered all the steps and what are the required percentages to deal with. So I can see you have raised the thumbs up to indicate that we are in order when it comes to such kind of questions. Now, D. Charity has experienced tumultuous financial times after securing the financial accommodation from Atlas Bank. As a result, Charity has defaulted on loan repayments, and the bank has already complied with the legal procedures necessary for exercise of the statutory power of sale. The mixed-use development is slated for sale by public auction in 7 days to come. Explain to Atlas the necessary prerequisites that should exist to permit it to purchase the property. And E, you can answer together with E. Explain to Charity on equity of redemption in light of the circumstances referred to in D above. So we are supposed to explain to Atlas Bank the necessary prerequisites that should exist to permit it to purchase that property. So they are looking at the procedure for statutory power of sale, and in this case you are already told that Atlas Bank has already complied with the legal procedures necessary for exercise of the statutory power of sale. So what are the necessary prerequisites that should exist to permit it to purchase the property? What are? Remember big key hapa, when we were doing the analysis of the Land Registration Act and the Land Act, we saw that if you are the one who issued out a certain loan amount and you want this property to be sold through public auction, there is a major requirement that you must obtain if you are dealing with a private auction as compared to a public auction. There is a key difference there. I'm the one who issued this loan, but now I'm pushing for the same to go under private auction. Private auction, nimecontract my auctioneer rafiki yangu, nikamwambia there is one of the clients who has refused to pay a certain amount. So from the phase of it, if you are engaging a private auction, there is a condition that you must fulfill, but in public auction haitakuwa necessary because the law will not, it is free for everyone to sell a property by a public auction. That is one of the exceptions that inaweza kuja pia watuletee now this time imeenda under private auction. So how will you explain the necessary prerequisites that should exist to permit the person who issued this loan to purchase the property? 5 marks, and then explain on equity of redemption in light of the circumstances referred to in D above. Yeah, so I'll leave the floor to you guys to try it out. Nowadays they have discovered that students crammed the 40, 90, 45 days, 40-day period wamemaster that procedure. So they are very deliberate in navigating around the same aspect of statutory power of sale, but the nitty-gritties that you never bothered to understand in details. Now hapa wamefocus on the aspect that there is a sale, public auction. Now they want to test, equity of redemption in light of circumstances, and the necessary prerequisites that should exist to permit the bank to purchase the property.
Are we saying that we are not required to give those steps all the way from the notice to sell to the auctioneers and the 14 days of the advertisement? Are we saying you're not supposed to do that now that the bank has complied with all the requirements?
Okay, in my view, nothing stops you from giving that answer. Inakaa ni the examiner ameweka a bait. Shakwambia that the bank has already complied with the legal procedures necessary for exercise of the statutory power of sale. Now, what are the prerequisites? So maybe in your view, the prerequisite is to confirm that the mandatory notices have been complied with under the legal procedures that they have undertaken, and your answer is still inclining to the step-by-step confirmation, of which that can also be an answer. But what if now the marking team will say, hey, look, we know of that procedure, but there are some necessary prerequisites that should exist whenever a bank is the one purchasing a property that it had loaned a certain amount in regards to the same. What if there is that provision on its own? So there is also a possibility of that, and then there is a possibility of the examiner expecting the legal procedural requirements where you tick the box as you have correctly inserted. So I've already preempted your answer that you could have chosen that angle. Yes, Abigail?
I think for me, I would have. Okay, I think I would have answered according to the hizo mambo na the right to get the best price and all that. So the prerequisite is to ensure that the higher bidder rule, that in as much as Atlas needs to is like when I intend to purchase the charged property, they must genuinely compete for the bidding process, that is the open public auction. And so wanafaa kuensure that the reserve price is the threshold is met, hiyo the duty for fairness and fairness, reserve price threshold, na ensuring that the first sale value haijapita, like haijaenda below the first sale value. So I think I would have answered on that angle.
Thank you, Madam Abigail, but your answer is inclining towards as if the auction has already happened. Remember, the auction is slated for sale. The property is slated for sale in 7 days to come, so it has not yet happened. What if Mr. Martin criteria is the one to be applicable to confirm before going into this auction? We have confirmed the necessary statutory notices have been served. But don't worry, we can also try out the equity of redemption as the next question, as we see whether we will have scooped any mark when it comes to that step. So prerequisites for Atlas Bank to purchase the property. Atlas Bank, being the chargee exercising the statutory power of sale, cannot purchase the property as an ordinary buyer without complying with Section 100 of the Land Act. Purchase with leave of the court. Under Section 101, a chargee may purchase the charged property with leave of the court, except in public auction circumstances permitted by subsection 3. So this is the part that I was emphasizing on. Under Section 102, the court will grant leave only if Atlas satisfies it that the sale to the bank is the most advantageous method of sale and complies with the bank's duty to obtain the best price reasonably obtainable under Section 97(1). So this at least captures Abigail's point on reasonably obtainable best price. So key number 1 is that purchase with leave of court. Under Section 101 of the Land Act, a chargee may purchase the charged property with leave of court except in public auction circumstances permitted by subsection 3. Now, the other criteria that the examiner will be looking at as a prerequisite is purchase at the advertised public auction. Since the sale is by public auction, Atlas may bid and purchase under Section 103(3) if its bid is the highest bid at the auction and equal to or higher than the reserved price with a greater applicable amount controlling. The bank should bid through an independently and properly authorized representative and complying with the advertised conditions of sale. So this is where Abigail's point will also be tied to this answer because you have already talked about the highest bidder or equal to or higher than the reserve price, so that will have scored you the second mark. Then there is the current forced sale valuation. Before sale, Atlas must obtain a forced sale valuation by a qualified valuer under Section 97(2) of the Land Act. It is mandatory. The reserve price must be informed by that valuation. Okay, so that is important. What sets up the reserve price? It is an independent valuation that is mandatory under Section 97(2) of the Land Act. So the bank owes charity a duty to obtain the best price reasonably obtainable. It must not structure the auction to acquire the property at an artificial undervalue. Prerequisite number 4 is that there is proper advertisement and genuine auction. Under Section 98(2) of the Land Act, the sale must be publicly advertised in a manner likely to bring it to the attention of prospective bidders. Atlas must also comply with the Auctioneers Act and rules, including the applicable redemption notice, advertisement, and auction requirements. The auction must be genuine, competitive, and free from collusion, fraud, suppression of bids, or preferential treatment of Atlas Bank. The fifth step is registration and evidence of compliance. Now, Atlas must execute the prescribed transfer by chargee and satisfy the registrar that Section 100 has been complied with. Under Section 104, the registrar may require evidence of the following. Do you have the court leave where applicable? Do you have the valuation and reserve price? Do you have the auction advertisement? What is the bidding record? What is the acceptance of Atlas bid and compliance with the conditions of sale? Atlas should therefore either obtain prior leave of the court or purchase at a genuine public auction through the statutory mechanism in Section 103. So these are the answers that I beg to differ with Mr. Martin and tell him to be keen that an examiner can choose any step in the statutory power of sale and focus only on that step. Like in this situation, they only focus on the auction part of it, and there are rules, there are procedures to be followed when it comes to either public auction or private auction. Okay, so let us be keen on that angle, because if you could have answered on the general notices required, automatically you could not have scored the 5 marks. And remember, there is also a question tied to part D. So if you fail D, chances are high that maybe the other question you could have also gotten wrong. So key takeaways is that whenever you're dealing with an auction kind of situation, focus on the auction prerequisites. Don't preempt. So do you have leave of the court? Do you fall under the public auction circumstances permitted by subsection 3? Because under section 102, the court will grant leave only if Atlas satisfies that the sale to the bank is the most advantageous method of sale and complies with the bank's duty to obtain the best price reasonably obtainable under section 97(1). So that is the exception that you can also be looking at. So the first step, do you have leave? Second step, have you advertised this public auction? And if it has been advertised by the auctioneer, have you confirmed that you are the highest bidder, or what informed you to come up with a reserved price? This is where you move to prerequisite number 3 on current forced sale valuation as mandatory under section 97(2) of the Land Act. So the examiner has seen you conducted the current forced sale valuation. There is a report to that. The examiner has also seen that you have complied with section 98(2) of the Land Act, that there is an advertisement in a gazette notice, newspaper of nationwide circulation, huko nyuma pages zile za mwisho. Is there any advertisement like that? Is the location where this auction is going to be conducted disclosed? Okay, is it in secret? No. Those are the things that the examiner will be looking at. And then lastly, do you do registration? Because you must also register the same, because there is the transfer of this kind of property under the Land Act for properties purchased via public or private sale. Yes, Madam Abigail.
Okay, I have a question on the practicality of the registration. I think the last step. So now after I think section 104 inasema that if a chargee who sold the charged land to the chargee, you apply to the registrar to be registered as the lawful owner under that land. So the requirement is that you have, when you're presenting that transfer document, you have to present any type of evidence showing that you had complied with the specific provisions, that is from section 90. And now if you go to, I think, section 102, it says that at any time before charged land is sold, the charger or the person entitled to discharge the charge may discharge the charge in whole or part by Okay, let me just ask. Yenye ilikuwa imekuja kwa akili yangu. My understanding of it is that if now the public auction has been completed, and then we as Atlas Bank, we have gotten we got the court leave, we did in accordance with the highest bid, and all that, hizo reservation prices and all that. Now the registration part, remember we also have to discharge that charge, because tushanunua, so the property, the charge is not there. So when we are going to register, can we also bring out the aspect of we have to, the requirement also has to be, but I think after that aspect of discharge, the full discharge, because in that question tunaona that yenye ilikuwa imebaki, I think ilikuwa ni 20 million, and then there was that 4 million. So in this case, will it be are we discharging only from Atlas, and then if it is just that, do we talk about partial discharge, and then is there any, in practice, can we discharge second charge before the first charge? I don't know, maybe you can also explain for me on that aspect. I've not interacted with it at all. Thank you.
Okay, thank you, Abigail, for that. And let me go back to this question so that you see what the examiner has done to prevent any kind of confusion arising. Amekwambia hivi that, acha nikusomee directly. Charity has experienced tumultuous financial times after securing the financial accommodation from Atlas Bank. So already you are dealing with Atlas Bank, and the examiner expects that all other issues to do with a discharge from ABC Bank have already settled, because now it is Atlas Bank ndio iko na power to execute. That's why they are entering into the statutory power of sale procedure. So at this point we have what we call tacking provisions. Tacking provisions ni ile wakati unaenda agree that my charge instrument will come in second priority, automatically now you can't execute kama the first chargee haja execute juu yeye ako na first priority because yako ni second. But kama alitransfer this ama in consideration of the money received from Atlas Bank, ilisettle ile amount na waka register a discharge of the same, na sasa title ikakuwa under Atlas Bank fully. Now that will mean that priority in executing already inakuja to Atlas. So examiner expect the angle of discharge at this point. It is already settled that it is Atlas Bank to do the enforcement. Lakini kama bado kungekuwa na ABC Bank imekatalia ikasema they want to issue priority ya kwanza yao ikue, when it comes to statutory power of sale ndo wana rank first, automatically Atlas Bank could not have moved even one step ahead kama ile ABC Bank haija initiate this procedure, because hao ndo wako na the priority if the tacking provision provides as much. So tacking provision is where you have the first charge and the second charge. So differentiate between first and second charge na further charge. These were the same bank facility inaamua kukupea another loan amount from the initial loan amount ilikuwa imekupea, so inaitwa further charge. So remember in question 1A Albert ametext kitu, and so remember in question 1A we had dealt with the transfer of the charge from ABC to Atlas. So ABC Bank was already discharged before Atlas advanced the loan. Okay, that's a very good observation. It's different from tacking. Good. So tacking, I believe, is there. Now kuna further advancement of another loan facility by the same institution so that equal further charge. Can you, Albert, confirm whether I'm getting the concepts right? Is tacking from the same bank, or it can also apply when I want to be registered as the second chargee of loan facility, or tacking is specifically limited to one bank? Let me confirm here from my end. Here you can also be helping me to confirm as we also think of question E on equity of redemption. So Madam Abigail, have I tried to answer your question? Because at this point kuweka hiyo angle itakuwa confuse the examiner. Because ni kama akiona umeleta ABC hapa ndani, automatically unaweza anguka hii swali. Yeah, so let us confirm that tacking is a meaning yake. Nani amepata answer? Under Section 82 of the Land Act, a right to tack further advances must be expressly stated in the charge agreement and noted in the land register. Okay, let me open a case law to see whether we have. So I've opened a blog known as The Law on Tacking and Consolidation of Charges in Kenya. The Land Act 2012 of Kenya governs the right and obligations of charges, and below is an explanation of these rights. I'm also sharing this to the group. We have tacking under Section 82. Tacking refers to the ability of a chargee to add further advances to an existing charge, thereby securing additional loans under the same security without creating a new charge. Section 82 of the Land Act regulates this practice as follows. Number 1. No general right to tack. Subsection 3 explicitly states that there is no right to tack unless expressly provided for in the charge instrument. This means tacking is not an automatic right and must be contractually agreed upon by the parties. 2. Further advances. Where a charge allows for further advances, the chargee may tack additional loans onto the existing charge, provided this is stipulated in the charge document. However, subsection 4 clarifies that if the charge provides for repayment of the principal sum by installments, such payments are not considered further advances for the purposes of tacking. Then we have priority of charges. Tacking does not affect the priority of the original charge. The Land Act emphasizes the principle of priority, where a charge registered earlier generally takes precedence over later charges unless fraud is proven. Tacking, therefore, does not inherently alter this priority but allows the chargee to secure additional advances under the same charge. What is the practical implication? For tacking to occur, the charge instrument must clearly outline the right to make further advances. Without this provision, any additional loan will require a new charge, which could affect priority, especially if other charges have been registered in the interim. So examiner akikuletea situation where there is a further advancement inside one loan facility but hakuna consent in the letter of offer, unaambiwa na examiner hawakuwa wameagree that the bank can do further tacking provisions, so automatically uambiwe kuna another bank sasa kuna right to execute, alafu unaambiwa bank A wanataka kuexecute on the further advanced loan without a consent, so automatically priority will shift to the second bank because further advanced ya bank A haikuwa na priority because of the lack of the consent. Now, section 83 ndio sasa tufunge chapter nitume this blog. Consolidation. Consolidation allows a chargee who holds multiple charges over different properties from the same charger or borrower to treat them as a single security, requiring the charger to redeem all charges simultaneously rather than individually. Number 1, right to consolidate. Subsection 1 provides that unless the charge instrument expressly states otherwise, a charger with multiple charges with a single chargee over several securities can discharge any one charge without redeeming all charges. This effectively limits the chargee's ability to enforce consolidation unless it is explicitly reserved in the charge instrument. And 2, registration of consolidation. If consolidation is agreed upon, subsection 2 requires the chargee to record this right in the register against all charges that are consolidated. This ensures transparency, clarity in the land registry regarding the chargee's rights. Then abolition of equitable consolidation rules. Subsection 3 abolishes the application of traditional rules of equity concerning consolidation upon the commencement of the Land Act 2012. This means that consolidation is now strictly governed by the statutory provisions and the terms of the charged instrument rather than common law principles. What is the practical implication of consolidations? Consolidation protects the chargee by ensuring that the charger cannot selectively redeem one charge while leaving others outstanding, provided the right is reserved in the charge instrument and is recorded. This can prevent the charger from undermining the chargee's security by redeeming only part of the secured properties. Let me send this blog to you, at least tumeelewa the two principles na tumeelewa the exceptions and the implication of advancing a further charge without consent from the initial letter of offer. So let me send that blog so that you read it on your own. So automatically we have answered Abigail's question, and now maybe a person can try out the last question as we purpose to end the recording because of time limits. So maybe a person can explain on equity of redemption in light of the circumstances referred to in D above. What is the examiner expecting to hear from a student when it comes to equity of redemption? Any attempt? Yes, Abigail?
My understanding is that equity of redemption is the borrower's right to reclaim the charged land or the mortgage property by paying off the loan that they had, together with the interest and reasonable cost, before the fall of the hammer, before the sale is completed. So in this case, the charger, that is the borrower, has that right to fully pay back the outstanding sum to recover their property, and this is provided for under section, I believe section, okay, I'm not really sure about it, but I think it's section 89 of the Land Act. So I don't remember who was the charger. I'm not really sure, but sikumbuki the person, but upon hiyo right to nini, especially because the facts pattern pia na the question D inasema that kutakuwa na kuna unintended public auction. So before that fall of hammer, that borrower has that right to pay back the property so that he or she is able to redeem back the charged property.
Thank you, Madam Abigail. But while still on it, do you think with that alone, ungepata the 3 marks? What is the other requirement that the examiner is also expected to hear out? Remember, we appreciated factual matrix. Tukaona if you are in a position to apply together with the circumstances referred in D above, then you will have answered the question fully. We don't want you to score 1 mark only in such situations. What is the other angle that the examiner is expecting maybe to hear from you? Yes, Albert? Albert, you can proceed. Your mic inasumbua. You're not audible, Albert. Yes, Abigail?
I think he was about to speak or something.
Oh, okay, Albert. His device has an issue. Albert, your microphone is having issues.
Okay. Okay, I think I can try. Maybe if what I would have done to scoop I don't know how many 4 marks, how many 2 marks, I would have talked about the number one, because section 89 in abolish your foreclosure, the foreclosure thing, that is the ilikuwa inasema that any like the right to the chargee's right to foreclose the equity of redemption is prohibited. So that is, I would have talked about that right to redeem as a right, and then tying it to D that there is no automatic sale. So there has to be the default on a loan does not automatically give the chargee an immediate right to sell that property without following the due process. And then that now the next thing I would have talked about here, the last thing I would have talked about maybe the statutory procedures. So the notices, formal statutory notices provided under the Land Act as well as the auctioneer rules, so as to show that the lender must follow the statutory notices. Yeah.
Thank you so much, Madam Abigail. So because Albert's mic is off, maybe Albert, you can type out your contribution in the chat box. Because of time, we will jump straight in. So charities equity of redemption, 3 marks. Equity of redemption is charity's right to recover. Yes, maybe Albert, is your mic on? But you have already exposed the marking scheme, so you will be bound by the marking scheme. Equity of redemption is charity's right to recover the charged property by paying the secured debt and performing obligations before the property is sold. That is a direct 1 mark. But the other 2 marks are captured here. Under section 85, 89 and 102 of the Land Act, Atlas cannot foreclose or permanently deprive charity of the right to redeem merely because she has defaulted. This is where Abigail will score the 2nd mark. Charity may discharge the charge by paying all sums properly secured, including principal, interest, and lawful recovery expenses before sale. Any term that unlawfully prevents or fetters redemption is void under section 85(2) of the Land Act. So these were charities. Madam Abigail's point is also emphasized that you can't unlawfully prevent or fetter redemption. Because the action is 7 days away, charity should immediately request a redemption statement and tender the full amount due. If Atlas refuses to accept lawful payment, she may deposit the amount in court where the statutory conditions apply and seek urgent relief. Importantly, under section 98(8) of the Land Act, property sold by public auction is deemed sold when the highest bid is accepted, not when the transfer is later registered. So charity's equity of redemption is therefore extinguished when the auctioneer accepts the successful bid. After that point, she will ordinarily not recover the land from an innocent purchaser. If the power of sale was exercised improperly, her principal remedy is damages under section 99(4) of the Land Act, except where fraud, misrepresentation, or dishonest conduct affecting the purchaser is established. Be keen on this kind of answering your questions. Abigail, in this question you could have scored 2 marks because you have not married your answer to the facts and the circumstances of the case, where the examiner is also expecting to guide charity on what to do. What is the step to request a redemption statement? What if Atlas Bank refuses to accept the lawful payment? Now, have you given the option of going to court, where she will deposit the amount in court, where statutory conditions apply, seek urgent relief like injunctions to prevent the sale from happening? Okay, so that is also another angle that the examiner was also expecting to see. And we have also seen another exception under section 98(8) of the Land Act, exactly when the right of redemption is extinguished is when the highest bid is accepted and not when the transfer is later registered. That will also captivate the examiner. And after that point, what happens after the right to redemption has extinguished? And this is where she will seek damages under section 99(4) of the Land Act. Remember, the examiner could have implicated a trick as if you are advising Charity on what to do and also advising Charity on the exceptions that are allowed in such a right and even the correct time to apply for this redemption. And in that angle of looking at it, automatically you'll end up scoring the 3 marks because the paper ya kujaza swali moja inakuanga 3 pages, 3 blank pages, so automatically the examiner expects you, if you have well read, ungekuwa na content enough to even marry your answer with the fact sheet. That's why we divided the answers into 3 steps. We identify the applicable explanation first, you score the 1 mark, then you go to the laws applicable, section 89, 85 and 102 of the Land Act. That's where now we invoked procedures laid out by Madam Abigail, but on the 3rd step is where students will fail. Now how you are likely, because you are explaining to Charity on the station amejipata nayo in D, so automatically the examiner expects you to also guide Charity on exactly what she should know on this equity of redemption and the steps to be taken. Up to that point, I believe we have indicated the correct way of answering the same and how to scope all the 3 marks at a go. So up to that point, I'd like to end the session, maybe to allow closing remarks because this paper appears to also maybe to avoid many issues zikifall due for Saturday. We can decide to do this paper tumalizie jioni, at least tuko tumemaliza conveyancing, because remember lazima tu balance hizi vitu. Tukiingia LWD sana, professional ethics sana, pia si poa. Conveyancing imetuonesha pia there are some areas hivyo tutaingia pia LPM, yani one way or another we must balance, at least tupate 50 over 50 kwa zote as compared to getting a 90 alafu ingine uko na 40. So let us speak in on balancing the same. So that is my closing speech mark, unless any other person. The floor is open because I want now to end the session to allow people to prepare for job. Yes, Mr. Martin. Closing statements. Abigail, how have you gauged yourself? Najua you have answered most of the questions. Now there is a level of in-depth analysis that you have conducted that is very visible, but PIA is also acting as a tutorial way by the fact that you are also testing yourself and how to answer the questions. Inakuwa a symbiotic relationship being created. So from my end, I have nothing else to say unless there is a member who has anything to add on. Thank you so much. Okay, I've seen all of your thumbs up, claps, Mr. Martin, Madam Abigail, and Mr. Albert, and that is a good gesture. Now, let me end the recording. Let us purpose to attend the evening session where we will be finishing up with this paper so that we get the nitty-gritties of conveyancing and not strictly jump to another unit first. Sawa members, so thank you so much. Let me end the recording. You are at liberty to leave the session.